Hi, my name is Goldman. I'm an attorney with Goldman and Associates, and today we're going to continue our educational videos about family law. Please subscribe to our channel. Today, the topic of discussion is, can my kids tell the court who they want to live with in a custody dispute? This is really interesting, and it comes about because we always get calls. Well, I want to get custody of my kids. My kid says they want to live with me. My kid prefers me over dad. My kid says mom's too high strung. Well, they want to reside with dad. Can the child do that? Well, the answer is not really. The child can express a preference, and amongst the custody factors that the court will consider is the express preference of a child of appropriate age. Generally speaking, if the kid is 12 years or older, they can express a preference to the court. The mechanism of it is usually when the court is conducting a custody case, the court will take the child in camera, which means in chambers, and ask the child if there is a preference. The court will not disclose what is said there. The court will not tell the parents who the child prefers to live with. More likely than not, the court will simply say that the court has had a discussion with the child in camera regarding preference, and leave it at that. The court doesn't do that because the court doesn't want to tell the parents, your child says they'd rather live with dad, because you know what life is going to be like once mom hears that. So no, the court doesn't do that. The court keeps it confidential in general, but the court will take that into account. It doesn't mean, though, that it'll carry the day. Just because the 12-year-old says, I want to live with mom, that doesn't mean that the court's going to go along with it any more so than the court might say, I don't want to go to school anymore. You know, this is a minor. We might hear what the minor says, but it doesn't mean we're going to follow it. Now, it's very, very different if the child is 12 than if the child is 17. If the child's 17 and says, I want to go live with mom or I want to live with dad, I mean, the court has to take that into account and give it a lot more weight, because at that age, you really can't tell the child where to go. You say live with mom, the child decides to live with dad, the child gets into a car and goes live with dad. That's it. And generally speaking, the court's not going to say, okay, I know you're 17, I know you want to live with mom, but because you're not yet 18, I'm forcing you to do this. Generally, the court will not do that. But with a 12-year-old, that's the age where the court begins to listen to the express preference. But again, it's only one of 12 custody factors. It doesn't mean that it'll carry the day. But if you have a child of at least 12 years of age or more and the child has a preference, it would be appropriate for your lawyer to introduce that and draw that out as evidence in the hearing, but to be taken not in and of itself, but in conjunction with the evidence on the other factors. If you have any questions about that, reach out, and of course, we'll be glad to help you out.